Okay, Mr. Janesk is joining now. Okay.
Will you, Ms. Coates, will you mute the...
Yes.
Thank you.
Okay, it's not letting me mute him for some reason, so I'm gonna send him a... Brian, can you mute your iPhone, please?
He's probably technically challenged.
Yeah.
We'll just get going. Good morning, Mr. Janesk.
Hey, good morning.
We're conducting interviews for Judge Christensen's seat. She has resigned a circuit court spot. Can you introduce yourself to the commission? I believe this is your first interview, and explain to us why you want to be a circuit court judge.
Sure. My name is Kenneth Janesk. I'm 38 years old. I've been an attorney for just 10 years now with the state since January 2011. I am married to my wife, Jennifer Dunton. We have a child. Our third anniversary comes up tomorrow. Our child's 5 weeks old tomorrow. So sleep is something that I haven't seen in a little while. But as far as being a circuit judge, I've been like I said, I've been with the state attorney for almost 10 years, a litigator for all 10 of those years. I think a judge is pretty much the pinnacle of the courtroom. It's something I've been going towards for service since I began, even before I went to law school. Service is something that's always been important to me, serve my community, no matter where I am. So again, I just feel like I can move from the state attorney's office service onto serving as a judge for the Seventh Circuit, taking over for Judge Christensen.
Mr. Janesk, there's kind of two questions I have, and I'll throw them out, both of them to you, and you can answer them hopefully. One is there's some people who think that you should be, 15 years or more practice, 20 years of practice before you should be a circuit court judge. So the first question I have is, how would you respond to that, only having 10 years? And the second is the lack of civil experience. How would you handle that?
Sure. I think first the question about the years in, to me, it's more of a quality versus quantity thing. If you look at what I've done in those 10 years, I've done 43 jury trials. Only 6 of those have been second chair, and I've done 10 non-jury trials. Also, as I was going down through those trials, again, going back to quality over quantity, only 8 of those are in the misdemeanor county realm. The majority of my trials have all been in the circuit court. They have been high-end cases. They have required DNA. They have required advanced sentencings, attempted murders, capital sexual batteries. So first off, there's more of the quantity over, or the quality over just the quantity, as well as when you look at my resume, I've been someone that's moved up well in the state attorney's office. I believe that's due to my maturity, maybe what I've done before I became a lawyer and whatnot. So again, I understand the argument of 10 or 15, 20 years. But again, I feel like I've taken my 10 years and really really put as much as I could in those 10 years. I've reached out to the community in those 10 years, member of the Rotary for 21, 22, I'll be on the board of directors in the Palatka Rotary, a board member of the Habitat for Humanity here in Palatka, on the education committee for the Florida Prosecuting Attorneys Association. All these things are just every opportunity I've gotten in my 10 years, I've taken advantage of and really put as much as I could into those 10 years. As far as the civil experience goes, again, you can see from my resume, majority of it is in criminal. I did put 2% as civil because of the sexually violent predator trials, or Jimmy Rice, what they used to be called. Like anything else, I didn't know criminal when I started. What did I do? I reached out to the best at my disposal and learned from them. I'm not someone who thinks I know everything, and I'm not someone who thinks I can just learn on my own. I'd reach out to the best. I would be mentor and be mentored by the best and learn everything I needed to. I'm not one that's going to go into a courtroom for criminal where I have 10 years experience and not be prepared. I wouldn't do it any differently as a judge on the civil bench. You research ahead of time, you figure out the issues, you figure out the procedure. That way you're not wasting attorneys' times, you're not wasting their clients' times or anyone else's time. I'm not going to learn it on the fly. I'm going to take the time to be prepared. One thing as a prosecutor is we don't punch out at 5 o'clock. Judge should be no different. So again, if I have a hearing coming up in civil realm, I'm not at 5 o'clock going to say, I guess I'll figure it out tomorrow. I would take the time to make sure I was prepared, fully invested, and fully prepared to take on that case. Also, because as a manager role, I also have the opportunity now to be in different areas of law, meaning when we have a case, say child abuse, I'm on the phone with the DCF, I'm learning TPR hearings, I'm learning their standard of proof and working with them to understand who has the better move, who has the better ability to get the desired goal. So while I do have criminal experience, again, I do work with the civil, I do work with family law, I have looked at other areas basically when it affects my case. Even things like financial crimes, there'll be a civil attorney. I don't think I can get into it because it's pending, but there's one pending where I'm working with a civil attorney because we're trying to get restitution. He's he's frozen the assets, so we're working together. I'm explaining to him my criminal aspect while he explains to me his civil aspect. So again, even though I haven't practiced in these areas, they're not foreign to me.
What about as a managing attorney, do you deal with HR issues inside the office?
I do. I deal with a ton of HR issues. Obviously, all of our HR does go through Daytona, but I'm part of all of that. If somebody's hired on in Putnam County, I'm going to be at the interviews. If somebody, even really with the circuit, we tend to meet as a group and interview people. When we talk about disciplining, when we talk about firing, anything like that, it's always a group effort, and I'm always a part of those. I'm also part of the local budgeting. When it comes to spending in my office, I'm a part of that, whether it be for depositions, anything is from hiring an expert down to the price of blue pens. In my office, I'm going to be involved in it as the manager.
Mr. Janesk, this is Mark Stanton. Could you explain the employment history that where you took a, I guess, sabbatical, did a case in Yugoslavia? Why did you do that? And kind of give me the nature of the case.
Sure. I wouldn't really call it a sabbatical. It was my last semester of law school. I did get law school credit for it. I was very fortunate. One of our professors, when the Soviet bloc came down, he went over there and he helped actually write about 15 constitutions. So his recommendations carry a lot of weight over there. So there's a program through Florida Coastal where you could apply to be an intern there. So I went over there. I thought it was a great opportunity. When else you have an opportunity to not only practice overseas, learn a whole different area of law, but also live overseas. So again, I was stationed in, I was sent to The Hague. I worked on the trial of Micho Stanišić. He was the equivalent of the Serbian director of FBI is what I would call him. So he was charged with war crimes over all of former Yugoslavia. The trial was every bit of 2-3 years. Every day we were in court for half a day. With a trial that big, we had to keep track of over thousands of pieces of evidence. We had to learn, I had to learn a different procedure, because there you had different witnesses. They called them, not to bore you, but they called them 92 bis and ter, because certain things as a trial, they had to establish that there was a civil war in the former Yugoslavia. Not many people debated that. So we had to worry about those witnesses versus actual eyewitnesses to the crimes. And Micho Stanišić no one ever alleged he did anything as much as he oversaw the full operation. So it was more of like call it a principal theory, is how it would translate here. So like I said, it was an opportunity that I definitely wanted to take. It was a great opportunity. It taught me how to organize a huge case. It taught me what it's like to be part of, I mean, you hear defense attorneys talk about, well, I represent a murder suspect. Well, I was on the team for genocide. So it definitely, humbles you to for the defense side and whatnot. So yeah, that was just a great opportunity. It was a great way to finish my law school.
Mr. Janesk, if you were selected by the governor and you were on a criminal bench, would you have the ability to, if the facts and the law support it, impose the death sentence?
I would. Again, I believe in following the law. If Florida has a death penalty and the law is followed, then I would definitely give the death penalty. Again, if I'm going to follow the law wherever it takes me.
Mr. Janesk, this is Mark again.
Yes,
When
sir.
I was calling some of your references, they said you actually requested to go to Putnam County. Is that true?
I did. It's ironically become a little a joke. So when I interviewed, I lived in Gainesville. I was living in Gainesville. Openings came in Daytona and Putnam. And when I went to interview in Daytona, I talked to them how I wanted to move away from Gainesville, move back towards the beach. And in Daytona, there's floor to ceiling windows overlooking the ocean. And so they all kind of said, okay, well, where would you like to be? And I said, Putnam. And they kind of joked. And one person told me to get a map. Mr. Larissa told him to, whoa, we actually have someone that's asked for Putnam County. But I did. I honestly, I love Putnam County. As an intern here, I met great attorneys. They're all in private practice now, but they really took me under their wing. The staff here is amazing. So yeah, it's kind of a little joke, but I definitely requested Putnam County, and candidly, I've never asked to leave. I've been really fortunate to continue to promote quickly in the Putnam office, but never really wanted to leave.
Thanks for saying that, not for Putnam County too. So,
I just want to remind everybody, Matt McLeod, John Alexander, Steve Alexander, Matt Klein, Andrew Morgan, Joe Boatwright, a lot of great attorneys have come out of either public defenders or state attorney's office in Putnam.
Absolutely.
Mr. Janesk, this is Travis Mata. Can you hear me?
Yes, sir.
What do you think are the biggest challenges facing a judge presiding over a docket in Putnam County?
So I think the biggest challenge of Putnam County, and this probably goes past dockets, is going to be the financial means. Putnam County is not a wealthy county. The tax base is not great, and that trickles down. It trickles down because the clerk doesn't have the funds that maybe a St. John's clerk has. The police don't have the same budget the police, St. John's or Volusia have, as well as the people. When you look at, and I didn't pull stats on this, but I would guarantee walking into a family bench, you're going to have more pro se litigants in Putnam County that could not hire a private attorney than you would in a St. John's, Volusia, or even a Flagler. For the criminal bench, you can see that our public defender's office and our regional conflict have absolutely more cases than their counterparts in other offices because the people are qualifying for the public defender's office. So really, I do believe whoever does get this position has to understand Putnam County. They have to understand that the financial means of Putnam County. It doesn't mean we throw up our hands and we give up, but it does mean that we have to address it. We have to understand it and sometimes get creative. When you don't have money, maybe you got to put in, do something else to get there. But that I think is the biggest challenge of anybody who's going to get into the bench in Putnam County.
Thank you. Could you tell us about your involvement with the Putnam County Bar Association? I know Gary Wood used to be the president for a long time, and now you've kind of taken the reins. If you could tell the members of our committee your involvement with the Putnam County Bar.
Yeah, absolutely. Again, Mr. Wood had it for a long time. After him, I'm not sure. I think he chose to step down. Mike Perry took it over for a year, maybe a year and a half. And then, honestly, Mike Perry emailed everyone, said, I for personal reasons, I can't do it anymore. And it was kind of like crickets. And I just felt like it was something I should step up and do. I'm in Putnam County every day, located centrally at the courthouse. So it just felt like it was something I needed to step up and do, take charge of it and try to make it better. Again, a lot of times with the Putnam Bar, we do 11 lunches and then we do that shad dinner. I've really tried to make it more interactive, more robust. We partnered with Judge Boatwright and we brought the teaching initiative back. We went through the training and then COVID happened. But again, we got a lot of members to go through the training. The idea was to get into the schools, teach civics from a lawyer's point of view. Again, and then COVID happened. We've tried to do a few other things and partner up. Again, COVID has limited what we can do. We can't really go to lunch right now or anything like that. But yep, I've taken the bar over. I've been excited to take it over and just try to bring it up to speed again, maybe a better functioning website, and we give back more to the members, whether it be through CLEs or more than just a monthly lunch.
Thank you.
Thank you.
Mr. Janesk, can you describe for us how, as a judge, you would interact with a pro se litigant?
Sure. Yeah, I would treat the pro se litigant like I do anybody else, a person, and not, you know, I would not be arrogant. I wouldn't talk down to them or anything else. If in my packet, you'll see that I had a pro se trial, and during that trial, you know, I treat him just like you would an attorney. Yes, sir. No, sir. Not gonna treat him any differently. The same way I do with victims when they come in here. I have some victims that come into my office mad maybe at one of my prosecutors or upset with the system, and honestly just take the time to explain things to them. Don't rush them out of there. Don't cut them off. Just really treat them like a human being and have patience. One thing that I do as a manager, which is sometimes different than just the standard prosecutor, is any given day I'm meeting high-end, very experienced litigator on the defense side. I'm meeting my best prosecutor in the career criminal division, talking about do we have the evidence to prove a capital sexual battery, an armed robbery, something very serious. But then 20 minutes later, I'm shifting over to speak to my newest misdemeanor attorney about derelict vessels and how are we going to get restitution, or who even gets restitution. And I do that all day. And in between there, I'm working with my secretaries who maybe their issue is something not legal at all. But again, I treat everyone the same. I take the same time for my misdemeanor guy, who to him, that derelict vessel is the biggest deal of his life, to the capital sexual battery, that is a huge deal. And I would treat the pro se litigants the same way. Maybe for me, a quick divorce hearing or or even a small, you know, call it a small civil with minimal money wouldn't feel like a big deal. But for that person who's pro se is taking their time out of their day, that's serious and obviously important to them. So I would treat them the same as I would anyone else. Don't waste their time. Don't be rude. And they deserve the same respect everyone else does.
Mr.
Mr.
Janesk.
Janesk, I'm sorry.
Go ahead, Charlie.
Okay, I'll take it. The challenge with pro se litigants is that they don't know the rules of evidence. They don't know courtroom decorum. They don't know how to present their case. They don't know what's admissible. And there you are as a neutral arbiter of the proceeding. So have you thought about those challenges and how to deal with those challenges when they confront you?
Sure. And there'll obviously be challenges. And I think, you know, at least on the criminal aspect, when anybody who wants to represent themselves, we go through Nelson Ferretta. And Ferretta is very clear. Do you understand you're not going to be held to any different standard than an attorney? If you're in jail, you're not getting any extra access to the law library. They explain that attorneys have been trained in the law and have spent years in education and training to get that way, and you'll be held to the same standard. So in that type of situation, obviously I'm going to be the neutral party. I'm going to be the referee in the middle, but I'm still not going, when they do try to put in something that they maybe cannot, and there's represented counsel on their side that objects, I'm not going to be rude about it. I'm not going to bark down at the pro se person because they didn't know. I'm going to follow the law, and I'm going to hold them to the same standard. But I'm not going to lose my patience with them because they don't know what they don't know. But again, at the end of the day, the law still will be followed, and they would still be held to the same standards.
Thank you.
Thanks.
Mr. Janesk, you have had an opportunity to practice law in front of now federal Judge Carlos Mendoza. What did you learn from him?
I honestly, you know, I learned a lot of things from him. I've had the opportunity to be in front of a lot of judges. And first thing I learned from him is the ability to move a docket efficiently, which I think is huge. The biggest challenge is when you, as an attorney, is when you can't get before the court or when you're waiting for an order. I think the biggest thing I learned from him is to follow the law. We had a trial at one point. It was a felon in possession of a firearm. It was like a .22 Savage rifle, and it hung on the guy's wall. He was absolutely in possession of it. He was the only one in the home. But you could tell judge didn't like the trial. We went to trial, we won. He was not found in actual possession, so the 3-year man wasn't there. And upon sentencing, Judge Mendoza's words were clear. When you find yourself between what you want to do and what you have to do, just follow the law and you can never be wrong. And then he sentenced the man. He sentenced him appropriately, he sentenced him lawfully. And again, he followed the law even when he didn't love the outcome, didn't love that I got a guilty verdict. He still followed the law. So really, he following the law, as well as how he efficiently moved the cases while following the law, is the two biggest things I've really learned from him.
Do we have any other questions?
I do. You had a very short naval career.
Yes,
Tell
ma'am.
us a little bit about that.
Yes, ma'am. 26 active days. Honestly, I was at the University of Delaware. I was graduating with, my degrees, and I really my parents are huge in education. So while some people say you got to get your high school diploma, it was very clear I owed my parents a college degree. With the last semester of before I got that degree, I decided I needed to do something in my life, and I thought no matter what, I needed to serve my country. I'm someone that has benefited from all the rights of this country. I got to be educated, I got to be safe, I got to be protected, and I just felt I owed my country that back. So I enlisted. I didn't want to be an officer. I didn't think my college degree gave me the right to lead anybody. I thought I should enlist and work my way up. So I did. I enlisted. During that time, at boot camp, I was born with this thing called reoptic orbital pseudotumor. It's a very long word that means I have a growth on my optic nerve that sometimes makes my eye hurt, candidly. With that, the military, I can do 1,000 things in the world. The military felt I could not be a part of the military. And I was discharged with what they call RE4 status, which means there's no surgery that could ever allow me back. Candidly, I went to law school in order to try to get back in. While I was in MEPS, which is the military entrance exam, it's the physical. I was next to a guy who every time he moved, his knees popped. He wasn't probably fit for full duty, but every time he didn't do well, the doctor said, "Don't worry, you're a lawyer." So at that point, I remembered, lawyers are held to a little different physical standard. Lawyers are not normally combat, ready, and maybe I can serve as a lawyer. So I went to law school, hoping that I could get back in. While I was actually in The Hague, I interviewed with the Army. The Army's closest recruiter was in Germany. So I jumped on a train and went to Germany to interview. Unfortunately, I was denied from the Army. Since then, I've honestly been denied from every branch. And now I've aged out. It's very clear that I can't serve in the military. But again, it's just kind of one more thing that I felt I needed to serve my country. And now I just have to do it in the civilian world.
Well, thank you for explaining that, because I wasn't quite sure what happened there.
Yeah, it's very random, I know.
Thank you.
Yes, ma'am.
So Mr. Janesk, at the end of the day, sometime I'm guessing around 5, we'll call you. Can we reach you around that time on your cell phone ending 66?
Yep, absolutely.
Great, thank you.
Thank you all.
Thank you.
Appreciate it.
Thank you.